and shine. Coffee's brewing, feeling fine. News is out and on the air. Shizzy Whiz nuts wild, but we don't care. Morning Whiz and coffee. Talk the news, he's a tease. Laugh it off, we're on the go. Shizzy Whiz nuts, start the show. Let's go. Spinning in the breeze, stupid jokes, he's such a tease. Sip the Java with a smile. Pants are off, but stay a while. Morning Whiz and coffee. Talk the news, he's a tease. Laugh it off, we're on the go. Shizzy Whiz, let's start the show. Let's go. Spinning in the breeze, stupid jokes, he's such a tease. Sip the Java, wear a smile. Pants are off, but stay a while. Morning Whiz and coffee. Talk the news, he's a tease. Laugh it off, we're on the go. Shizzy Whiz, let's start the show. Let's go. Serious is overrated. Every day we're caffeinated. Talk the town, but in a jest. Morning Whiz is always best. Clock is ticking, time to run. Morning show's a load of fun. Grab your mug, don't spill a drop. Laugh your ass off till you pop. Clock is ticking, time to run. Morning show's a load of fun. Grab your mug, don't spill a drop. Laugh your ass off till you pop.
Oh my god, Shizzy breaks Larry. Shizzy broke Larry.
Good morning, everybody. Good to see every single one of you. Welcome to another one. It's going to be good today. I guarantee it's going to be beautiful. No matter where you're at, I hope you're having a wonderful day. Already, the sun is up. Pickles, howdy. Good to see you. Conversations with RJ. Good morning. Oh, yes. Good morning, Jim, Cynthia. Hello. I have my favorites. Good morning, Shizzy and Shad. Wonderful to see you have my favorites. I hope that you're doing well today. Yes, it is going to be a wonderful day. Good morning. Remind Shizzy, trash day. I know exactly what you mean. Oh, yes, Ray McIntyre. Good to see you. Oh, it is such a glorious day. We are looking to have so much fun. All right, Tammy. Hey, Emos, good to see ya. Oh, yeah. So what we're doing is we're continuing on with more of the Laura Owens trial. I mean, there's more information before that. And one of the things I'm going to show you today is this is 3 days before this pregnancy video that she keeps talking about. Just to give you an idea of how strange it was for all of this. Now so I want you to pay real close attention to this. This is all these are brought to you by Schnitzel Ninja, which all of these videos can be found there. It has the whole collection of Laura Owens videos. That includes Ecker's, that includes all of her other trials, other hearings. That they've gotten copies of, plus some other really interesting things. But let's show you this. Just remember, this is 3 days before the pregnancy.
This will be your first trip here. Entry number 169, Sirocco 91. Owner-writer Laura Owens out of Scottsdale, Arizona.
So keep in mind, this is the video that she took and sent to him, and this is her competing 3 days before this video. Three days before this video, this is what she's doing. I'm going to turn off the audio just so you can see exactly what she's competing right here. Now, if you're that pregnant, would you be out there doing this horse riding? What do they call this? Steeplechase? Is that what this is? Very, very interesting. That pregnant? No, not that pregnant in 3 days. No, this is her competing, and this is what she looks like at that point in time. Just showing it so you can get an understanding of what they're talking about in these videos. Stole my identity as John Doe. No, Stephen, I don't want to be anywhere near that. And so is it possible that her gut is out there like that? I mean, there is that possibility. But would you want to be competing like that? Putting that much pressure on your body? I wouldn't, but I'm not a horse rider. But even if you're a professional rider, you'd be careful of your baby. That just looks pretty dangerous. Yeah. So that's the 3 days before. Now back to the video here. Hold on. Why does it continue playing? There we go. So we are picking up where we left off. If that qualifies as pregnant. I've been pregnant for years. Not that much on the pelvic floor. Ah, yes. I've seen you in other chats. Hope you have a great Monday. Good to see you, Diane Humphrey. Thank you, dear. I hope you do too. Well, especially that so-called preggers. I've said it before, and I'll say it again, Laura. Should never. Well, that would be between her and her guy. No, not me. I don't make that decision. I don't make that decision at all. So let's carry on with this cross-examination.
I've offered to give you control over the outcome of the pregnancy if we date exclusively and care for each other, correct?
Oof.
Correct, which was one thought on one day, and I took that away after, yes.
Gosh.
And this is the exact same statement that you made to Mr. Gillespie back in July of 2021, isn't it?
I have no idea what statement I made to Mr.
July of 2021. So you have to understand here, this is in November of 2023. She's found a new guy, knows it's twins, high risk. Really? Yeah. What's her weird camera rule? What's she doing? Well, see, here's what's going on. She's been sent copies of these documents that she's reading, and most likely she's on like an iPad or something of that sort. And so she's flipped the iPad around so it's vertical so she can read the whole thing. And she, it's just what, oh no, the voice. I followed this case when it was going on. I'd forgotten that vocal fry. Yeah, totally. It happens. It's a guy that was told he was the dad and turned out an ex got pregnant before I meet my ex. One needs to be thrown in jail and the keys thrown away. She has wrapped her eyes like Jen McCain. Yes. She looks dangerous. All right, let's continue on.
Mr. Gillespie, but both pregnancies have been medically proven, and I have the documentation and sent it.
But Ms. Owens, all right,
Owens.
We can't keep everyone talking over each other.
I sent the HIPAA records. I released my HIPAA records.
Ms. Owens, there's no question before you.
The HIPAA records. Please, I sent them. I did it. I did this. Oh.
I'm asking the court to strike these statements. All right. So let's try to just answer the question.
I don't know what I said in 2021.
Okay, so if you don't remember, just say, I don't know what I said.
I don't
And,
know.
that if I said that. Okay,
I don't
there we
know.
go.
Yeah.
All right, so but we have room for like one more question, and we're going to be doing closing argument.
And Your Honor, again, I would just ask that in lieu of closing argument that I be permitted to ask.
I've already done that.
Okay.
We're already at 11:56 at the moment. So,
Okay, Your Honor. And here, Ms. Owens, isn't it true that you alleged you were pregnant with twins with Mr. Gillespie in June of 2021?
No, that was an email that he doctored in 2021 that I have already testified about that in the other case. So no, I never said I was pregnant with twins.
So now it was a doctoring. It is a doctoring. HIPAA records only mean you were made aware of your HIPAA rights. No, it's supposedly, yeah, that's it. I agree with you. That's all that it means. She's saying that she gave, yes, there are no HIPAA records. HIPAA is the law regarding the release of medical information. Exactly. What she's trying to refer to is that she basically gave all medical information already, which, gives up her, it keeps those where and not any person can see them. Doctored like on Fiverr. Exactly, Jim. Exactly. That's exactly it right there. Oh my gosh.
Can you please take a look?
Again, this was an exhibit that whatever it is, I'm guessing I know what it is, was one message that was doctored by Mr. Gillespie that appeared a year into the court case I had with him.
right, and we've already discussed the fact that I'm not really considering all of that. So let's move to closing.
Your Honor, my concern here, and again, I mean this with all due respect, but Ms. Owens has a pattern of behavior here. She has previously made identical allegations in another case. The exhibits that I have today,
Look at her flip. Look at her flip.
all support that the statements she's made to Mr. Eckert are almost identical to statements made to Mr. Gillespie in 2021. This is highly concerning behavior. She has now perjured herself on several occasions during testimony, and I am not being given the opportunity to show the court the documents to support that she is lying under oath.
I have proven my pregnancy and had my records sent to Mr. Eckert.
Okay, Ms. Owens, Ms. Owens, we're not testifying right now.
I'm sorry.
Even if it was true that Ms. Owens did that in the past, which we are denying, but even if it was true, that has no relation to this specific case. Just because she may have done it before doesn't mean she's doing it now, and we have presented evidence showing.
Oh, yeah. So when you have an epical, possibly. Oh my God. Get the straitjacket ready. Yeah, you can tell she's flipping out. She's losing her mind. The judge should let all that information in. Well, exactly, Pickles. And that's a very big possibility of what is going to happen. All this information is going to be coming into her case that the state is building against her. It's high protein. Oh, absolutely has relevance. You're right. It does. Well, and this is the kind of stuff that comes back to bite her because she's made multiple statements, and then she's backed off of them saying, no, I never said that. Well, you said it before in other cases. You've played these games before in other cases, and it's showing a pattern of behavior.
Showing that she is pregnant. We have presented evidence showing why
that's
she is.
false.
We're going to do closing arguments now. So whoever wants to do a closing argument, Ms. Arena, go ahead.
Your Honor, this is a clear case of harassment. The court has seen through all of the exhibits submitted by Mr. Eckert and the additional exhibits that were presented today that the parties had an encounter in May of 2020. Mr. Eckert did not have sexual intercourse with Ms. Owens. Shortly thereafter, Ms. Owens began claiming she was pregnant with Mr. Eckert's child, with an alleged child. Mr. Eckert repeatedly, from May to today's date, has pleaded with Ms. Owens to stop contacting him. He has blocked her number on several occasions, and she gets a new number and or uses an app to continue contacting him. It has not stopped. Mr. Eckert has lost job opportunities, speaking engagements. He has suffered extreme emotional distress over these claims that are baseless and over her repeated outreach attempts after pleading with her to stop. This is the definition of harassment. The court's well aware harassment is defined per the statute as a series of acts over any period of time that is directed at a specific person and that would cause a reasonable person to be seriously alarmed, annoyed, or harassed. And the conduct, in fact, seriously alarms, annoys, or harasses the person and serves no legitimate purpose. Ms. Owens has fabricated a pregnancy now twice on two separate occasions. Mr. Eckert is the second victim of
There goes the eyes.
She has provided no medical records to support that she is in fact pregnant.
There she goes.
As the
Eyes
court
again.
saw, her Exhibit 46, Your Honor, is not medical records to support a pregnancy. It is merely, and I'd like to draw the court's attention to this, it is a picture of a test completed at Banner on June 1st of 2023 regarding HCG. It does not say it is a positive pregnancy test. The next page, Your Honor.
Oh, I'm sorry.
This is not your turn.
I'm sorry. It does. Okay.
It's not your turn.
It is very questionable, as a woman who's been pregnant before, that Ms. Owens goes to Banner to get an alleged pregnancy test on June 1st, and then she never goes back to Banner Health for any additional testing. The next page of this exhibit is simply a screenshot of an upcoming appointment with a Dr. McCool on Monday, July 24th, 2023. There are no records to support that she is an active patient with Dr. McCool, that he is her perionatologist. There's nothing. We just have a screenshot of an appointment that was made, which anyone can do online. The next record, Your Honor, this is now a HCG test from any lab test now in Scottsdale. This is not a positive pregnancy test. This is a positive HCG test. Why is she going to a new provider for a alleged pregnancy test on October 16th?
Yeah, that's the doctor.
Next pages of records, Your Honor, are it's hard to tell what they are. They look like they are screen grabs of an appointment that is unclear. It's just unclear. At the root of this case, and the reason that Mr. Eckert is fearful, scared, is the fact that there has been a fabricated pregnancy. She has participated in several paternity tests, none of which have come back showing any proof or any signs of fetal DNA, Your Honor. If it wasn't for the fact that she has done this before in another case, this is unbelievable. It is very alarming. She lied under oath, and she lied under oath at the last hearing. She's not being truthful today, and my client is legitimately fearful of what else she's capable of. He's asking that this court recognize that he has done everything to handle this appropriately. He has begged and pleaded with her to stop contacting him.
Dr. Jellyfinger.
There is no reason for these two to have communication, despite what Ms. Owens will say regarding this alleged pregnancy. There is no proven pregnancy at this point. So we are asking that this court find that she has harassed Mr. Eckert from May of 2023 up until today's date, and we're asking that the court find that the injunction against harassment needs to be ordered and maintained.
Thank you, Mr. Lopez.
Yes, Your Honor. Now, I would agree with Clayton that Laura's communications with him were
That's right,
alarming,
Nanny Goat.
annoying, harassing, if in fact Laura wasn't pregnant, and if in fact he wasn't responding to her through the over 4-month period that she's been pregnant. She is pregnant, and he has been responding. Clayton has not met his burden in this matter. He's claimed that the amount of texts and emails has caused him to be alarmed, annoyed, harassed. Well, for starters, the reason there are so many emails and text messages is because the chosen form of communication between Laura and Clayton was through emails and text messages, and because that was how Clayton wanted them to communicate.
Well, yeah, because whenever you, and we've seen this with Doozy, will use the phone and then claim that things were said that were never said, that times were happening that they never happened, you know, and he's done this with multiple attorneys, with multiple people. And there's that kind of misbehavior of looking at something and saying, listen, I have been reaching out to this person. I've been talking to this person. This is what the context of our contact was about. But instead of having that written proof of this is what was discussed, this is what we said, this is how we handled the situation, what she's doing is he said, listen, if you're reaching out to me, it's going to be by text or by email. I'm not talking to you on the phone, mainly because he probably doesn't want to hear her voice. Well, it's not about, and see, this is where it becomes such a big problem. It's not about believing all women or believing all men. It's knowing, being able to parse out the truth, you know, this belief that happens, you know, because guys can be just as much of a shit as women can. In this case, he just happens to be a woman, you know, but yeah, this is one of those things that got pushed out there and was happening at the same time. You also had the same thing that was happening with Johnny Depp. I mean, years earlier, this kind of behavior of just believe all women or believe one side of the story. Look at the whole of the information, and you can make up your mind yourself. And this is why having that kind of proof, those kinds of email exchanges, those kinds of contacts are very important, is because you don't want it coming back and saying, well, I never said such and such and such. And he's been able to pull up those emails, those contacts, the images that she sent, the kinds of information that she gave to him, and be able to prove that in court. This is what happens. Not true. You can't absolutely believe everyone. That is absolutely right. And it's not about, you know, this really puts a damper on women being able to come forward. This is why this a case like this was so important. Everyone's lied about being pregnant. You're fibbing right now, Yamaha. This is where it becomes very important for people to understand, is that, you know, it's not about believing one side or the other, or having this thought that they're doing absolutely everything properly and correct. What it's showing is this pattern of behavior that she's got, this pattern of behavior of things that she does, and being able to show, hey, you know, she's ruining the chances of a woman coming forward and saying, listen, X, Y, and Z happened. And all of a sudden now, because of her attitude and her lying to the court and her lying to people, has made it where it makes women a little bit more nervous of coming forward and speaking out if something bad were to happen to them. Because, you know, now they're thinking, great, nobody's going to believe me because we've got this crazy person that goes and says X, Y, or Z. And now we don't believe women at all. I ain't never believed Yamaha, even when he said it wouldn't hurt. Well, it only pinched a little bit. It only pinched a little.
Communicate, not in person, not over the phone, but through emails and text messages.
Yes, as you should.
And second, we are talking about a span, again, of over 4 months or more. There are going to be a lot of text messages messages during that time. There are going to be a lot of emails during that time. Third, he claimed in his petition that he has not responded to Laura and that he has blocked her. Now, that is clearly a lie. And
Sir, I would object. That misstates the evidence. There is clear evidence to support that the messages are showing from a blocked sender. That is not accurate.
Your Honor, some of those messages may have been blocked, but there are other communications in the exhibit, in Clayton's own exhibits, that show that he did respond to my client, whether it be in emails or text messages, and we've provided those some of those exhibits in the ones that were admitted to this court. Now, Laura testified that there was communication even aside from the exhibits that we've presented. It's impossible to put all the communication within over 4 months into a short hearing.
Well, yeah, I agree. And that's why you're bringing in as much as you possibly can and putting those into context and showing exactly what's happening. If I'm not mistaken, this attorney ended up leaving after this. Just didn't want to have anything to do with her. She went through several attorneys because of the misbehavior that she was doing. And the kinds of the kind of attitude that she had towards her attorneys was pretty bad. It was, and if you've got an attorney, you don't want to just be swapping attorneys back and forth, left and right, because at some point it just starts to look really bad. I can understand if cases like this, and Deb showed you why proof means more than fiction. Absolutely. That Ballstorm's hitting it absolutely right.
Essentially. Now, I want to talk about the content of that communication. All of the communication from my client to Clayton was meant for legitimate purposes and not to annoy him, not to harass him, not to alarm him.
Yes, it was.
Almost all communication between Laura and Clayton was for the purposes of the pregnancy and paternity. The only other sort of communication from my client toward Clayton was in relation to the post that he put online when my client would receive harassing messages from Clayton's fans and his followers. So the communication around that time, call it.
See, this is where it's completely different. So you can't blame that person unless they're directing those kinds of things towards a person. If these people are reaching out to her, which I would hope that people don't reach out to her and don't harass her and don't talk to her, don't give her any of this kind of ammunition. If he's reaching out to her and directly harassing her, that's on him. If the judge is reaching out to her and harassing her, that's on the judge. It goes to the person that's doing it. Now, if Clayton's telling the judge to call and harass her, that's a completely different story, because then that's one person telling other people to go harass another person, and that would get you in trouble. But that's not what's happening here. He's posting what's going on with his stuff, then other people are taking it upon themselves to go and harass, which doesn't help him out at all. So whenever these people that think they're being helpful by harassing, by going after people or attacking them, they think that they're helping out, they're being helpful, they're actually harming him in the worst possible way, because then it looks like he's doing something which he's not. So that's why it's best not to bother people and let them spin into their own shit story.
August, September was toward Clayton, asking him to take those different things down so that my client wouldn't be harassed. Throughout.
Well, you don't have to remove things because somebody else is being bothered. He wasn't posting anything about her home address. He wasn't posting anything about her email address. He was just showing this is the things that she's saying to me, and I'm here defending myself. Good morning, the lovely Miami Spice. I hope that leg day was really good for you today. Good to see you. Yes, or in Lowe's cases, it's not hard to swallow. Maybe get a police sketch artist to identify the offending member. God, shame on you.
This entire time since May, Clayton has never been clear with what he's wanted to do. He's been wishy-washy the entire time. First, he didn't believe that my client was pregnant.
Yeah.
So she sent him proof, and she sent him proof again. He wanted numerous forms of proof. You saw in our exhibit the video of Miss Owens pregnant. That was a video that Clayton asked my client to send to him. How can you?
And you saw the video of her 3 days before. You saw the video of her 3 days before competing in the horse competition. That's what showed up. That was the first thing that I showed you guys. 3 days before she claimed that video was taken of her with undeniable proof that she's pregnant.
You ask someone to send you proof of their pregnancy and then now call it harassment. Now say that you're alarmed. Now say that you're annoyed. Now say that you're harassed. That doesn't make any sense. He was also wishy-washy about what should be done with the unborn children. And we're talking about at the beginning, around May, June. Should these children, should she have the children? Should they be aborted? Are we going to give them up for adoption? Am I going to have sole custody? Is she going to have sole custody? He was never consistent with what he wanted.
Well, she was never consistent with what she was. I mean, you know, she swallowed and was pregnant.
I'm sure that he was, I'm sure maybe he thought one thing one day and maybe he thought something else another day. And then he thought back to we didn't know what he wanted. And that was communication that was going both ways, back and forth between Clayton and Laura. Again, he hasn't been consistent. And that is what the root of this problem is. That is why there's so many communications back and forth. Had this been done in person, had they chosen to meet up physically or talk over the phone, things wouldn't get lost in translation through email, through text.
Oh, no, because then she would have tried to spin it a different way. Now, had they had those conversations over the phone, they would have been spun into a weird situation, because then it's, well, he said this, and whenever he clearly didn't say X, Y, or Z, if you have it in email, it makes it very clear. If you have it in text, it makes it absolutely clear what's being said, what exactly is going on.
But that's how they chose, that's how Clayton chose how he wanted communication with Laura. And that's what made everything so difficult. During this time period, Laura actually had to hire another attorney to help facilitate paternity testing. That didn't work, so then Laura had to file a matter out of the family court to create a parenting
These are not
plan.
facts and evidence at this time. These are exhibits that Mr. Lopez did not get to present.
I think she testified that she filed a paternity lawsuit.
And they did not have, neither of them, my client nor Clayton, have had an attorney in that family matter, so they are forced to communicate with each other because they needed to meet and confer. They needed to submit a resolution plan, so there's going to be text and communications back and forth from the two of them. Everything that you've heard during.
And he said, this is why I want to have, good morning, my dudes, a Flux sighting. Good morning, Flux. Good to see you. What, I can't show my fake evidence? Surprise face. Exactly. Oh my gosh, hold on a second. All right.
Whether it was our case in chief or the petitioner's case in chief, this is a snapshot of what has happened over the course of over 4 months. We were not able to present everything. All communication between my client and Clayton were for legitimate purposes. Again, not to harass him. Look at the exhibits. Look at the ones that Clayton submitted. There are clear exhibits that show that he was sending messages to her. We have submitted exhibits showing that Clayton had been communicating with her. So the fact that in the petition itself states that he had not responded to her, that's completely untrue. he had indicated in his petition that my client had harassed him. Well, that's not what happened. Who was the one that was posting videos online and getting harassed? Clayton was posting.
That's not harassment. If she's being harassed by third parties, that's on the third parties, because he's doing whatever he can to show exactly the kind of behavior that's happening. Now, all that she would have to do in response to that kind of behavior that's happening, if she believes that she's in the right, is she can show the proof that this is not what's happening. This is exactly what's happening. But she never did that. You know, instead of doing what a normal person would do and say, "Hey, this is not true. This is what we have going on." Yeah, it's the channel that's causing it. I'm sorry, Pickles. I really do. It sucks. And hopefully they have it corrected at some point in time soon. Maybe today, maybe tomorrow, maybe next week. She grew her tonsils back after this episode. Gave her baby tonsils.
In the videos, my client was getting harassed. Not one communication.
And that's the thing, is people shouldn't go out and harass people at all. They shouldn't do that. That's just not appropriate in any way, shape, or form to be harassing.
There wasn't one communication that indicated after they had been in communication since May. Since then, there was no communications that were sent to my client telling my client, stop texting me, stop emailing me, stop calling me. Not one. They presented one exhibit that shows one message that indicated that, oh, I may call the police, something like that. It seems like he might be worried. But since then, he had been communicating.
Oh, and the police did get called. We'll be watching one of those today also. Notice how her attorney keeps covering his face. Yes, exactly, Tammy. What about harassing companies? Can we do that since it isn't a person? I don't know. I mean, here's the thing. You pay the credit card bill, Flux, and then they stop calling and harassing. Just kidding. Just kidding. Oh, you know, well, I keep getting those calls for AARP. It's just like, stop bothering me. Oh.
With my client. So again, you can't say that you are being alarmed, annoyed, harassed, but then going ahead and then emailing my client, texting my client. And again, for all of those reasons, I think that the communication between my client and Mr. Eckerd were for legitimate purposes.
Okay.
For the to determine pregnancy itself, moving into determining paternity itself, to trying to schedule paternity testing with the attorney,
Mad Dog. What's up,
the
brother?
family court
Good to see you.
matter, and to today. And so for all those reasons, we're requesting that this be dismissed. Thank you.
Your Honor, in rebuttal.
Is it the same thing, though? Is my vehicle warranty and paternity coverage the same, though? That's the question. Good morning, Melody. Good to see you. Wonderful, wonderful. Oh, my gosh. Oh, my gosh. I hope you're doing well this morning. Just accept your senior discount. Oh, what you mean is the check bounces. I still have checks.
So none of the communication from Ms. Owens to Clayton has been for a legitimate purpose. As the court has heard today, it is clear there has been no DNA test or test of any kind to support that she is allegedly pregnant with Mr. Eckerd's twins. There is no reason for these parties to communicate. What Mr. Lopez is proposing is that if you block someone, but they find another way to contact you, and then you tell them you still don't want to talk to them in a polite email or a polite message, then that's not harassment. That is the epitome of harassment, Your Honor. The court has received exhibits in the first hearing from Mr. Eckerd supporting that she would find other avenues to communicate with him after he has blocked her. Again, it is Mr. Eckerd's position that that this pregnancy has been fabricated. And I want to be clear on this, Your Honor. It's possible that Miss Owens is pregnant. But it's my client's position that he did not have sexual intercourse with her, and she is not pregnant with his alleged twin. And that is the root of the issue here. There has been no support for this alleged pregnancy, other than her attempt
Rickles, good to see ya.
show the court and or Mr. Eckert a picture of her alleged pregnancy, which again, we suspect may still be fabricated. So there has been no legitimate purpose to her communication other than to harass Mr. Eckert to try to force a relationship on him. She told Mr. Eckert on multiple occasions that she was going to force him to communicate with her, whether he wanted to or not.
Oh, yeah.
And he has been clear. He does not want any additional communication from her.
Yes, he has.
So, as I stated when we first started this hearing, I'm not making a determination as to whether or not she's pregnant or not. That is a family court matter. That case is pending before the family court. The testing or whatever is going to happen is a result of that. So I'm not making a decision and a determination today whether or not there is a valid or invalid pregnancy. I understand Mr. Eckert's position is there isn't. I understand her position is there is. That's where we are.
Yes, that is what they never had sex. Nope, they never had sex. She let's put it this way: she swallowed twice and ended up with twins. That's as far as it went. Allegedly. I mean, I wasn't there, so I don't know. But from what I've been able to garner out of all of this is that she has her uterus has moved from the lower nether regions into the upper regions of her body. Make her give DNA can be done before birth. That was the problem. They did a DNA testing and they never found. They found little or no DNA, which is basically saying, yeah, there's not enough there to determine whether she was even pregnant at the time. This is why she said, this is epitome. Don't stick your dick in crazy. The only thing is he never did. Poor Clayton having to deal with crazy. Poor guy never knew it was coming. Well, she did. She knew it was coming. She felt it all over.
Oh. With regards to the evidence and the communication, the court at this time does find there were a series of events
Where's Lord Chippy?
At the plaintiff that would cause a reasonable person to be alarmed, annoyed, or harassed. That he was, in fact, alarmed, annoyed, or harassed. I do find they did not serve a legitimate purpose. Messages that have been sent. One, he blocked her on numerous occasions. She even said in the blocking communication, can you unblock me so I can unblock you again? I got a new number, and then there's another new number. I think that's clear that he does not wish to have communication.
Ooh.
The nature of the communication, while maybe surrounds the pregnancy, the communications that I have a lot of concerns with are the ones where she's trying to make offers to him to continue a relationship, that she is trying to facilitate, if you do this, then I'll give you this. Those kinds of messages are of the nature that are harassing and can be viewed as alarming, annoying, or harassing.
Yeah, because if you're making these kinds of communications and the face you make when injecting horse piss, and that's what it is talking about, is like if you're reaching out, you're making these communications. Well, you stop doing this and I'll start doing this, and trying to create some sort of that becomes harassing. Like, you need to do this or this is going to happen. Those become harassing communications. Hey, thank you, Bad Duck. Well, you know what, Bad Duck? It is beautiful to see you. And boom, he says, I mean, if Clay had a duck corkscrew, he could have tickled her belly button from the inside and she would. Wouldn't have nothing. Good to see you, Pat. Let me go grab my helmet really quick. I'll get you your star after the break, and I will be doing a break here coming up right after this. We'll be doing a quick break so you guys can go fill up on coffee again.
There are a number of messages that were admitted that are attempts at, I view kind of almost as trying to, get him to do and agree to things that are not necessarily, it's not like we said, hey, can you take the paternity test? And he said, no. Hey, can you reconsider? I want to do a paternity test. And then I went and filed a lawsuit because you wouldn't do it. I mean,
right.
That's one thing. 500 emails, back and forth, or messages, I'll say text messages and emails.
Can you imagine 500 messages or emails? I mean, 500. Funny how her face went angry eyes. Yeah, she's looking pretty angry right now. Her going to discuss is just going to be an expensive way of being told to kick rocks yet again. Yes, the angry eyes. They can someone email me a coffee? I'll never make it into the kitchen. Oh, just waddle in there. You got it.
Over that period of time to try to clarify and do that is beyond what was necessary to be able to communicate those things. There were a number of threats to go to the media, which were other additional attempts to try to use the media as manipulation, or the threat to go to the media as manipulation. I find those to be...
Yes, threatening to go to the media as a means of manipulation. That is that right there. I mean, you start piling these things on top, and her doing the TED Talk, where it ends up being a one-sided conversation. Doesn't help her case at all.
Alarming, annoying, or harassing. So I am going to grant the injunction at this time.
There it went.
What is going to prevent any communication outside of the legal process, and specifically legal process and court hearings. So I am going to grant the injunction, and so I will sign the granted injunction today. And then I know Ms. Owens isn't present, but we can give a copy of the signed injunction, obviously, to Mr. Lopez today. But whether or not ultimately she needs to be served with it so that the service of the injunction is appropriate, because it will go into effect once the injunction is served upon her. It would remain in effect for a period of 1 year. This was the hearing that she had as a result of that.
Yes, I do.
An additional time to request an additional hearing. And if you guys want to wait for a few minutes, I'll sign an order. If there were exhibits that you did not offer that you wish to have returned to you, you can let the clerk know and she can release those back.
Thank you.
Thank you.
Thank you.
Yes, he didn't. Oh, he did not stick around much after this. Yeah, the look on her face. Oh, she is angry.
I need a hearing letter too.
Looks good. If you land on the floor, you'd be begging me, please don't hurt me no more. Oh my God, I need more coffee. That was long-winded. It was long-winded, but we will be having a break here. Get to feeling better, Bad Duck. I just want to see if there's anything after this, if something happens that I might have missed towards the very end, and then we're gonna have a little quick coffee break. Possibly with someone's favorite song. We'll see. I'm seeing if there's anything more after this. And then whenever we come back from the coffee break, we will have a beautiful open letter in response to this. So hold on for it. Shuffling papers. And it looks like that is it. Yeah, he looks completely defeated on that one. I think she broke the screen. It's a possibility. All right, let's do this. Let's get yourself a nice little morning coffee break, and we'll see you in 3 minutes and 20 seconds, and we'll have a letter for you. So hold on tight.
shores, get a tan, Rambo the orangutan. Driving a golf cart, oh man, Rambo is half crazy, yes he can. Well, that SOB's a sight to F and C. Oh, Rambo's rolling, rolling, rolling. As the sun, he's free at last. While Shizzy has his coffee, these two are having an effing blast. Whoa, Rambo's rolling, rolling, rolling. As the sun, he's free at last. While Shizzy has his coffee, these two are having an effing blast. Shizzy on the dunes, coffee in hand. Rambo is a loon, and Shizzy is, well, that is too dirty to say here. Shizzy on the dunes, coffee in hand. Rambo is a loon, and Shizzy is a, that is too dirty to say here, Oh, Rambo's rolling, rolling, rolling. As the sun, he's free at last. While Shizzy has his coffee, these two are having an effing blast. Otters in the surf, hummingbirds in the sky. Rambo honks the horn and spits in Shizzy's eye. Oh my! Oh, Rambo's rolling, rolling, rolling. As the sun, he's free at last. While Shizzy has his coffee, these two are having an effing blast. Oh, Rambo's rolling. Rambo takes a turn, driving to the waves. Otters wave their paws, telling Rambo, not sure, but if you could understand, Otter, it probably wasn't nice. Rambo takes a turn, driving to the waves. Otters wave their paws, telling Rambo, not sure, but if you could understand, Otter, it probably wasn't nice. Oh, Rambo's rolling, rolling, rolling. As the sun, he's free at last. While Shizzy has his coffee, these two are having an effing blast. So here's to Rambo, otters and hummingbirds by the edge of the ocean. And Shizzy, well, he might just be there too. Here's to Rambo, otters and hummingbirds by the edge of the ocean. And Shizzy, well, he might just be there too.
Oh, and I mean, if Clayton had a duck corkscrew, he could have tickled her belly button from the inside, and she wouldn't have nothing. Well, thank you, Bad Duck, and you are completely right. Thank you, sir. You get a star. Isn't that thing getting all sparkly and pretty? Oh, yes. Thank you so much, man. I appreciate you. Yes. And so, as I said, we are going to have a beautiful open letter, and I hope that you enjoyed. If you haven't seen one of these, well, it's going to be a treat. I guarantee freaking to you if I can actually find the little intro to it. I know it's here somewhere. Man, I really suck at this some days. I know that I do. Let me see if I can find it really quick. I think I have it right around here somewhere. Oh, there it is. Yes.
It is about time. Let's break this mother down. With Shizzy, Whiz, Nut,
Your testimony wasn't just bad, it was a full-length feature in self-destruction. To the one that might have swallowed, you had one job: tell the truth, or At the very least, pick a lie and stick to it, but what you delivered on stand was less defense testimony and more extended panic attack in slow motion. If what you did on that witness stand qualifies as testimony, then I'd like to formally nominate every drunken voicemail I've ever left as admissible evidence. You didn't testify, Laura. You failed. You flopped. You performed in the most embarrassing, credibility vaporizing way imaginable, like a walking rebuttal to your own defense. I've never seen better consistency in a magic 8 balls, and you know about those balls. You gave more versions of your story than there are aliases in your case docket, and each one made less sense than the last. Watching you testify is like watching someone try to lie their way out of a maze they drew themselves in Sharpie while blindfolded. You didn't just contradict yourself, you practically held a workshop on how to do it efficiently. One minute you're confident, the next you were confused bystander in your own story. You managed to sound simultaneously coached, unprepared, and shockingly unaware of what case you were even in. You couldn't even keep your story straight for longer than a sneeze, and when facts boxed you in, you went limp and played the victim like it was the last role left on the casting sheet. Let's talk about the greatest hits of your courtroom crash and burn. You claimed you didn't intentionally mislead anyone, but then the spun tales were so convoluted, even your old lawyer looked like they were silently begging for the fire alarm to go off. You backtracked on key points, blamed your disability, then insisted you were mentally sharp enough to navigate complex legal issues with precision. Which is it? Are you a vulnerable victim of misunderstanding or a tech-savvy truth teller wrongly accused? You can't be both, Laura. That's not a defense, that's a personality disorder. Let's take a little stroll through the wreckage. First, you claimed you had no intent. Then you claimed you had no memory. Then you claimed you had permission. Then you claimed you didn't understand the permission. Then you pivoted mid-sentence to suggest the permission didn't even matter because you never touched anything anyway, even though you had already said you did. It was like watching a Roomba try to escape a circular room. You kept bouncing between, I'm a helpless, disabled woman with no grasp of what's happening, and I'm the smartest person in this room. How dare you question me? Often in the same breath. You try to present yourself as overwhelmed, confused, and outmatched, but your tone gave away the truth. You were arrogant enough to think you could spin the court in circles. You believed you could outmaneuver the people who had literal video exhibits, forensic timelines, and your own digital footprints. What you didn't count on was that your mouth would betray you. Harder than a hot mic at a confessional. Every time you opened it, you added a new contradiction to the record. Every sentence was a shovel. Every pause, a backhoe. You know about those hoes. You buried yourself in real time. The court didn't even have to hand you the dirt. And then when cornered, you didn't assert, you imploded. You folded like laundry in a powder outage. You blamed confusion, miscommunication, disability, stress, my understanding of the order. And once, I swear, the moon's gravitational pull. But here's the hard truth. Nobody buys it. Not because you're a sympathetic figure, but because your story changed too many damn times to matter. The moment your mouth started freelancing from your brain, you stopped being credible and started being a cautionary tale. Let me be brutally clear. The problem wasn't the state. The problem wasn't the judge. The problem wasn't some ADA conspiracy in a courtroom misunderstanding. The problem was you. You torched your own defense from the inside. No one needed to impeach your credibility. You committed public character suicide under oath. You couldn't just lie once and write it out. No. You had to revise, embellish, retract, and reframe in front of the same people you expect to believe you. And now you want the public to think you were railroaded? No, Laura, this wasn't a railroading. This was a demolition, self-inflicted, full speed, and painfully public. It went deep, it went hard, it went fast, but it never touched your nether regions. You didn't just testify, you detonated, and everyone in that courtroom watched the fuse burn out with a mix of pity, disbelief, and secondhand embarrassment so strong it should have come with hazard pay. If justice is blind, your testimony was the clanging alarm bell that she couldn't ignore. You made her put down the scales and reach for the Advil. Sweetheart, this isn't a tarot reading, it's sworn testimony. You acted like every question was a surprise party. You spent more time second-guessing your own answers than a college student with text anxiety on Scantron. And then you try the pity card, the tears, the trembling voice, the sudden fragility. But here's the problem. It only works if the rest of your story doesn't scream manipulation. You wanted to be seen as vulnerable, but your smug corrections, your interruptions, and your weird bursts of legalese made you look less like a victim and more like a control freak who finally ran out of narrative runway. You got caught, Laura, not because the prosecution was good. Let's be honest, they could have been replaced by a sock puppet with a printout. You got caught because you couldn't remember which lie you told last. That's it. Your own ego tripped the wire. Your mouth detonated the device. Your testimony wasn't inconsistent. It was performance, a bad one. And I don't mean amateur theater bad. I mean read for the part of law-abiding citizen, didn't even get a callback bad. You brought this entire house of cards down with nothing but your own breathless explanations, your defensive outburst, and confused attempts to play both hero and victim. The only thing you proved on that witness stand was that you're not a reliable narrator of your own life. And when push came to shove, and oh, it did, your story, it folded faster than a dollar store lawn chair at a family barbecue. So here's your round of applause, Laura. You stood before the court, swore to tell the truth, and then proceeded to reenact every episode of Scooby-Doo where the villain accidentally confesses during the chase scene. You didn't just sink your credibility, you wrapped it in concrete and you rolled it into the river with maximum sarcasm and a stiff drink of secondhand embarrassment, shizzy Wisnut, self-appointed bailiff of bullshit detection, coffee-stained courtroom critic, and the guy in the back row whispering she did it after every lie, Supreme Court jester of judicial face palms, patron saint of cell phones, and still not confused about what testify means. And most definitely not your daddy. There we go.
It is about time. Let's break this mother down. With Shizzy, Whiz, Nut.
Oh my gosh. Morning, everybody. Yes, you got to see one of those live. And it's not that you get those. When she has his helmet on, he means business. I knew that you'd like that. She says he needs to do a letter for her mother. Oh, we got some more interesting stuff for you today because this happened on December 8th, 2023. And let me just pull this up so you can see this, and we're going to be going through a few of these. Now, this here is the Scottsdale Police Department phone call made on December 8th, 2023. Now, I want everybody to be warned. There may be things in here that are disturbing. Just know that there are places you can reach out and you can contact if there are things that you find that are disturbing and you feel triggered. I suggest that you reach out and contact those people and take care of yourself and your well-being. So here we go.
Scottsdale Police, this is Kate.
Hi, I wanted to call in a wellness check from an article that was posted online last night.
Okay. All right. Do you know the address?
I do not know her address.
Yeah.
Her name is Laura Owens.
Do you know her birthday or approximately how old she is?
She's 33.
Okay. And what kind of article or what's making you want to check on her?
She posted a Medium article, which is a blog post, and she's supposedly pregnant with twins right now, and she's put in her article that the relentless bullying, which is there's a really long story about it, and I don't know if you guys know, but she has said that she's on the brink.
I just want to say that I love that picture. That's awesome. Thank you, Web. I appreciate it. That's awesome. Oh,
causing moments of despair when I'm close to the edge of despair.
Ooh.
And she expressed to someone that if she harmed herself, that the blood would be on his hands.
Yeah, this right there should give people concern, and there would be something, there would be a reason why you would want to contact somebody to do a wellness check on that person, especially if they're saying these kinds of things. Those kinds of statements, right there should get some sort of wellness check. Absolutely.
So it sounds like something's really wrong.
So she was kind of I'm sorry, can you repeat what she said about the blood on someone else's hands?
It's to a guy named Dave Neal. Her quote from her article, her blog post said, "His relentless bullying has pushed me to the brink, causing moments where I felt close to the edge of despair. I even expressed to him that the blood would be on his hands if I harmed myself due to this relentless harassment." She's not being harassed. She's actually a harasser. And if she's pregnant and she's telling people she's going to kill herself, it's a little scary.
Yes, that would be scary.
And you said the guy's name was Dave Neal, as an N as
Dave
Nora?
Neal.
It could be.
Neal?
N as in Nora, E-A-L.
Okay.
Oh.
Okay. And why are you calling the Scottsdale Police Department? Do you know that she lives here?
I do know that she lives there.
Okay.
And let me put on the closed captions so you can see those. Type, clickety, clack, 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 click, click, clack, 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 tippity, tap, tip. And this would be.
My name.
What's your last name?
Do I have to tell you my real one because I'm literally scared of this person?
Okay. No, that's okay. Do you have a good callback number?
I do. You won't share that outside of the police department, right?
So just because we don't have a address for this person, I can still put a call.
I do have her address.
You do have her address? Okay, I thought you said you did not.
I do.
Okay.
I'm
What's
sorry,
your
I
address?
do. I do. It's
And they're holding off the phone number for it.
She lives with her parents, Jan Black and Ron Owens. She lives in the casita in the back of their house.
Okay, so do you know her personally?
I do not. There's a really weird public story going on, and there's a lot of court cases going on, and she's like continuously threatening and harassing people. But her being, I think there's a lot of mental illness things going on, and she's constantly threatening to hurt herself, and she's supposedly pregnant as well.
Okay, gotcha. Oh.
Brainworms.
All right.
Could
and
be.
Can you just confirm that number for me? Your phone number for me really quickly?
Yeah.
8675309.
Okay. And did you want, I'm going to put this in, but the officer may call you for more information. Do you know her personally, or is this?
No, this is all. No, this has been going on for like 6 months publicly, but it's just like she posted a blog last night that it just felt like a big spiral, and I'm afraid I honestly think this girl is going to hurt herself or other people.
Okay.
That's a valid concern.
Okay. All right. If the officers don't need any additional information, did you want to speak to them, or did you just want them any follow-up from them?
Whatever works for you guys.
Well, it's up to you.
Yes, I would love to know, or, yeah.
Okay. Okay. I've got this in. We will go out and check on her and make sure everything's okay.
Okay. Thank you so much.
Well, I wonder if she had the post to forward to the Popo if it would warranty a 72-hour hold. I mean, it always could possibly be. I think you warranty. Geez, autospell. It's okay. I understood. Warrant. Yeah, it could warrant a 72-hour hold. We got you. We got you. I wonder if the Scottsdale 911 had a hot sheet for all the number of calls that came in on her. It's a possibility. I mean, it may have just been one person reaching out that was concerned because, you know, if somebody is threatening self-harm, you want to make sure that they receive all the help that they possibly can receive.
You're welcome.
Okay.
Now, this here is Laura Owens, Clayton Eckford. This is prior to all of this. Now, this is a 17-minute video clip, and after that, we will probably end the stream, and I'll be sending all you fine folks over to see Mo. But let's just give this a listen, just to get things set up. So this is prior to her other hearing.
All right, good afternoon and welcome. We're on the record FC 2023-052771 in the matter of Lauren Owens versus Clayton Ray Eckford. Miss Owens, are you present on the line?
Yes, I am.
Ma'am, can I have you state your name for the record, please?
Yeah, it's Laura Owens.
Thank you, and if you'll raise your right hand, let me know when it's up. I'm gonna have you sworn in.
It's up.
You do solemnly swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, thank you, Ms. Owens. This is a hearing on your petition for order of protection. I'm going to ask you some questions about your petition. Before I do, are the statements alleged in this petition true and accurate to the best of your knowledge?
Yes.
And the nature of your relationship with the defendant, Clayton Eckford, is what?
So I'm pregnant by Clayton, and so we also had a romantic relationship.
Okay. Do you currently reside together?
No, we do not.
And are there currently any orders in place, protective orders in place involving either one of you?
I have a protective order against somebody, but there's nothing between us.
So she's already got a protective order against somebody else. Mm-hmm. This shows that she likes to get those protective orders for no reason.
Okay. Now earlier, well, let's see, it's been a couple weeks. A couple weeks ago, you had filed a petition against Mr. Eckford involving some of the same circumstances that you've alleged in this petition, and the court at that time denied your petition. You know what allegations I'm referring to?
I do, yes, and there have been more, and there was even another one just since I filed it this morning.
All right, and I appreciate that. I saw that in your latest petition. The point I want to make is that because the court has already ruled on those other incidents, and specifically the one with the date associated with June 10th and the other with the date associated with September 21st. We're not going to talk about those issues today, but I do see that your latest petition does have events that are alleged to have occurred with the dates and I'm going to quote your language, between 9/22 and 10/5. And then you have another event that has a date associated with it.
Well, this is the, if I'm not mistaken, this right here was the first OOP hearing, which basically just it's a protective order hearing against Clayton. So this is prior to the hearing that we saw earlier. and doesn't raise a red flag to the judge. Oh, it does. It does. This all raises red flags, but still they can do this. I tried to get the court said it was ridiculous. How can I stay away from myself? Logic, whatever. Good to see you.
Of 10/6/2023, where you were referred to since September 28th. So let's talk about those events in that time frame. What is it that Mr. Eckert has done, and when did he do it?
Yeah, absolutely.
Mm-hmm.
So I just want to make sure. So, can we talk? Or did you? I'm sorry. He had just done something, and I'm really upset. So you wanted to talk about like when he posted to his followers about to look up my court cases against the man I have the protective order against.
There's nothing wrong with that. You know, it's for people to look up court cases. There's nothing wrong with that. So asking someone, say, hey, look up these court cases. If you don't believe what I'm saying, look up the court cases, and the facts go to show exactly what kind of person that we're dealing with here. You know, you're doing this to expose these people that are filing, you know, protective orders left and right. And this is something that she was doing. She's filing these protective orders and saying, you know, this person's looking to harm me. You know, and you know, if you sit there and say, hey, you know, this is what's going on, people are like, oh, I don't believe you. Well, look, you can look this stuff up for yourself. You can see exactly. It seems just like a chicken herder chasing those all day long. Yes, chasing chicks all day long. That's what it is.
Yeah, and I can facilitate our communication. Let me do this. Did any of the posts refer to you by name?
They did not, but he said because I asked to remain anonymous in this whole thing, but he said to look up the post by his name, and because of that, I've been named by like everybody online.
Okay, but did Mr. Eckert post anything that referred to you by name?
No, he did not.
Well, there you go.
Mr. Eckert post your case number in any of his posts?
He said to look up the case number.
All right, and
you know what,
so he provided his name, right?
Yes, and he told people where to search on the Maricopa County website.
All right.
Okay.
And what are the statements that were in the post that referred to you specifically?
So he said that I had done this.
That's absolutely right, AT.
And gotten pregnant by 2 other men before, which is true. And
yes, this is an ex parte hearing. Well, and in certain cases like this, you can do that. You know, especially if you're looking for a protective order, then yeah, you can have a hearing like this. The judge is being as thorough as he possibly can. For the reported activities, how could she even see his face?
After he did that, he has posted many times just facts about the cases. In one of the cases,
he can do that.
I have a civil case, and they're both against the same man. I have a civil case that I had given discovery materials to the man in the civil case, and Clayton was able to get a hold of those and leak those documents online, which those did have my name on them.
Okay.
And then Clayton has now posted that the results of the paternity test came back, which they did not, and he said
that'd be interesting.
He's not the father, and again, they did not come back. He's posted this, and so then I'm just getting harassed like crazy. I just have to go and submit a
like crazy.
So he's really gotten people.
So let me ask you, and here's the line of concern that I'm in what's directing my question. So, folks that communicate things publicly have a constitutional right to that includes a freedom of expression.
See, and this is why the judge is very hesitant on all of this, is because whenever people are posting things publicly, they do have a freedom of expression. It could be anger, frustration, whatever it might be. You still have that freedom, and he doesn't want to take away his freedom from posting things online or talking about things. You do have that ability. It would be a different story if he's out there saying, you know, the X, Y, and Z about a specific person, or he's telling people go and do X, Y, or Z to this person. And he's not doing any of that. He's saying, go look this information up on your own, and you determine whether I'm true of what I'm saying or if it's not. Oh, damn, that snap, that pesky Constitution. Yes, exactly. Allegedly, LO can't go into hospital without attacking the Wiener cartel. It's not illegal to be mean to you, ma'am. Thank you, Judge. Then go to the constitutional right we have in any case. Mm-hmm.
And so long as their communication is not illegal speech. In other words, it's not, well, illegal speech can include a number of things, but if the comments are true, or rather if the comments are not untrue and they're not illegal speech, then they are generally protected free speech. So what is it about these posts that you claim are not protected free speech?
Well, so in the first one, when he said the initial cases, I guess I should have explained that a little more. He tried to make it seem like I had faked being pregnant. That was
make it seem like.
that I had quoted.
All right. So how did he insinuate that? So and here's and this is let me distinguish between what I'm asking and what you're saying. So you can't draw the conclusion. All right. So tell me, what is he saying without you drawing a conclusion? Because some people may not draw the same conclusion as you. Use his words and tell me what it is that he said that you think is unprotected free speech, or not that's not free speech.
Just that he said he said that on his page, and then on Reddit he went online and he named me and he accused me of faking pregnancies.
He named you,
and he has cussed me out on there. He's harassed me. He himself had said that I really should kill myself on Reddit. And
again, did he refer to you by name when he made that statement?
On Reddit, yes, he did. He referred to me by Laura Owens. Every time he posts on Reddit, he posts my full name.
Okay. And then when you use the word harass, what is it that you mean?
Well, I mean, like when he said that I should kill myself, and when he said that he said online that I have lied about being.
Well, and if I'm not mistaken, these are things. Judge needs examples. Can you show me the examples of where he said that? She ate a burrito and is not pregnant with a Mexican baby. Damn, Stephen. Yeah, judge needs examples, and if he's truly telling her, to self-delete, then yes, that right there would be enough to most likely. And I mean, like I said, I'm not an attorney, but I would think that right there would get you into some hot water. But from what I understand, he never did that. That was something that she made up to try to get this protective order.
Pregnant when I have not, and he has absolutely no proof that I did, and I've provided all this medical evidence to prove that I was pregnant, and despite that, he's just trying to incite people against me who have just been horrendous to me online, including him, who has multiple false accounts, fake accounts that leak information that only he would have about me, and like I said, every Reddit.
Well, that right there could be, yes, if that's what he was truly doing. But from what I understand, it wasn't. People were digging on their own and pulling up that information.
He just has my full name. He lists my full name everywhere.
Okay. Other than through legal counsel and court proceedings, should there be any path of communication that's left open between you and Mr. Eckert?
Just the paternity case. No, I guess there's nothing else that needs to be left open.
All right, and the North 69th Street address in Scottsdale is your home address?
Yes, it is. Yeah.
And then, do you know whether Mr. Eckert uses or has access to firearms?
I do not know. I don't believe he does.
All right. And then I know that you have language here that says, I'm looking at your proposed form of order. It says no cyber harassment or cyber bullying under real name or pseudonyms. I'm fairly certain I understand what you're asking, but can you explain what you're asking the court to order if I were to grant your petition in terms of cyber harassment or cyber bullying?
Yeah, I guess him not posting on Reddit trying to incite people against me, or he just did this YouTube, or I'm sorry, this Instagram post where he's trying to incite people against me by saying that that these test results are back when they're not, and he's name calling on Reddit. And he sent my attorney a message from an email address saying Laura Owens liar at gmail.com.
Well, that right there would be for the attorney to handle, and the attorney doesn't have to send those on to you. Sounds like a listener.
.com, and so I guess not that, like just I just want him to kind of just stop all of this. I want him to just, be a truth teller and stop harassing me, I guess. I'm
But he has to tell my truth. My truth.
not explaining it well.
Okay. I'm going to type some things into your order. Let me tell you, Ms. Owens, I'm going to grant your petition.
See?
I'm going to issue an order of protection that includes you as a protected person and include your home as a protected address, leaving open only the path of communication that Mr. Eckert is not to have contact with you except through legal counsel and court proceedings.
See?
And then I'm gonna work on some language here for a moment that addresses the issue about what's going on online. And then I'm going to read that to you and see if there's anything that you wish to have change. So give me a moment while I do that, and then I'll read to you what I have, okay?
Oh, okay. I mean, he can, I don't mind if he emails because we don't have counsel in the paternity.
Oh, see, now, I don't mind if he emails me because, well, you email me, call me, Clayton, call me.
Case. Neither one of us does. I just basically, I just want him to not, be that character assassination or anything like that.
I don't want him showing people what exactly the kind of shenanigans that I'm pulling online.
That,
Okay, but in this day and age, people have different opinions about what's character assassination, and that's what I understand what you're saying, and I believe that you have a particular idea about what you're saying, but to use that term or cyberbullying or cyber harassment, those are amorphous terms that don't have strict boundaries. So I'm gonna work to communicate that. But you want to leave open a path where he can email you regarding the paternity case?
Yeah, just because we don't have counsel.
Okay.
So he can't point out my lies in public. Yes. For corn up. You went to see Muppets and wound up with a frog in her throat. Jesus. I don't want him telling people that I'm a crazy person. Call me on the line. Call me anytime. Call me Call me anytime. Call me, call me. Oh yeah. So the judge is wording this to be a little bit broad, but to basically put some type of protective order. Now, this is where it becomes so to prevent future pregnancy should she get a tonsillectomy. Now, see, this is where it becomes really touchy. Now, if she breaks that protective order because she's posting things up there, that becomes a real problem.
Language in your order that says defendant shall have no contact with plaintiff other than as outlined herein, and shall not cause others to contact plaintiff other than as outlined herein. And I'll read that to you in just a moment. I have also included language that says defendant shall not communicate or post untrue or harassing comments regarding plaintiff online, including but not limited to social media, and shall not cause others to communicate or post untrue or harassing comments regarding plaintiff online or otherwise. So
now this is where it becomes really touchy, because what if it's true? So him saying, these are cases that she's involved in would not be an untrue comment. It would be a true comment that those are cases that she's involved in. And he won't have control over other people of what they post or what they say. That would be, him pretty much backing off and saying, okay, I can't say anything that might be construed as untrue, but I can post things that are true. And that would not break that restraining order. Also note that this becomes a really bad problem, the way the judge is wording this, because what can happen is, and I'll just use this for example, say for example, I'm given an order not to discuss X, Y, or Z. I'm not allowed to talk about a certain person. So what happens is then Volstorm posts something up on the interwebs about her, then the judge can come back and go after me saying, look, you broke this protective order. So this is why it's always helpful for people not to get involved or post things on the web about other people, because then you start breaking all kinds of orders that can cause more and more problems. This is not something that you want to have happen. You want to make sure that these kinds of things, that you just stay out of it. Let the court handle it. As frustrating as it can be, that can get the other person in trouble. But also that becomes a bigger deal, because especially whenever you've got thousands, you're always doing something wrong. Whenever you've got these kinds of problems that are happening, the judge improperly worded this because how am I supposed to know what Volstorm is doing? Because I don't know. So yeah, if he were to be out there posting something, I can't stop him, and I can't say anything, because if I do, he might just decide to do it anyway. So that's where it becomes a problem.
I've tried to leave that vague, and I've tried to leave it.
And vagueness is a problem.
Interfere with individuals' constitutional rights.
But it does interfere with the constitutional rights.
With that with that understanding, is there anything you would have changed about what I just read to you?
I think that's absolutely perfect.
Okay, and then the outlined is herein. I'm going to read that to you in just a moment. Let me just make sure I didn't miss a word or anything here.
Missing words.
Okay,
well, this is why judges are hesitant about doing things like this.
It says defendant shall not contact plaintiff except as checked, and I've checked the box other, and then it says through legal counsel in court proceedings and through electronic mail only regarding only matters pertaining to the paternity matter. Anything
That's
to change
perfect.
about that?
Oh,
No,
absolutely.
That's perfect.
All right, so this order of protection, Ms. Owens, will not become effective until it's served. It'll be sent to the sheriff's office today for service. But after this hearing, I'm going to have my office send you a copy of the order in case you need to involve law enforcement sooner than it may take the sheriff's office to serve your order of protection. Understand that while we'll send your order of protection to the sheriff's office today, it may not be served today. It may take a day or so. But if you need to use that copy before then, look for the email after the hearing and you'll have the copy available to you to use. Okay?
Okay, perfect. Thank you so much. Thank you so much.
You're welcome. Just a little more information. The order.
Well, and see something, and you make a really good point. So, you know, this is the same kind of thing as saying to somebody, cover this story, cover this story, cover this story, talk about this, talk about me, talk about me, talk about me, talk about me, and then coming back and saying they're talking about me. You know, that's where it becomes a big issue. And we've seen this kind of behavior, especially online. You'll see people that will invite you to cover a story, to talk about a story, you're covering this story and you need to have this information. And then whenever you talk about it, they get bent out of shape and say, oh my gosh, how dare you talk about this? Well, because you invited the conversation. Be a squirrel boy, protect your nuts. Exactly. Guys for lunch. I hear she's cutting down. Familiar. Yes, it is. What are the actions for any false claims? Are there any? Well, and see, you have to understand that this would be just a temporary order, and then you would have a hearing over this. So that there is realms to do this. So the minute that he gets served, he can file something in response to it. But in the meantime, he would cease all communication except for what was outlined. That's how you would handle something like that.
Protection becomes effective when it's served, not before then. And then once it's served, it will remain in effect for a period of 2 years, unless before then it is dismissed or modified.
Now, see, that's where he's talking about it. Will she have to close down the Laura Owens? That's so bad.
Could request to dismiss it or modify it, or Mr. Eckert could request a hearing contesting it. If he requests.
Now, see, there it is, right there. Does that answer your question? Where is it? Right here. That should answer your question right there. Because what he's saying is he can request a hearing on this. So if that explains it, and I'll let you hear it again, just so you understand what the judge just said.
You could request to dismiss it or modify it, or Mr. Eckert could request a hearing contesting it. If he requests a hearing contesting the order of protection, you will have the burden of proof at the hearing to show why the order ought to remain in place as issued. Okay.
Okay, so does that make sense? What actions are available to rebut any false claims in protective order? Well, and all it would be is him coming in and contesting it. So there you go.
Okay.
Anything else for today?
No, thank you so much.
You're very welcome. We're adjourned for today.
And that right there ends the joy of the beginning of all of the Laura Owens craziness. And everybody, I want you to have a wonderful day. I'm going to be sending you and doing a little drop ship over to Mo in the Deep End. Make sure you go and show her a little bit of love. Plan on probably having a stream tonight, because it's just getting crazy out there. So we will see exactly what's going on, everyone. Until then, have a wonderful day, and I will see you guys very soon. And I guess that's about it. Enjoy. Peace.
Bless your heart. I thought I was the only mentally challenged one here.
Get it, yeah, oh yeah. rise and shine. Coffee's brewing, feeling fine. News is out and on the air. Shizzy Whiz nuts wild, but we don't care. Morning Whiz and coffee. Talk the news, he's a tease. Laugh it off, we're on the go. Shizzy Whiz nuts, start the show. Let's go. Get it, yeah, oh yeah. Headlines spinning in the breeze. Stupid jokes, he's such a tease. Sip the Java, wear a smile. Pants are off, but stay a while. Morning Whiz and coffee. Talk the news, he's a tease. Laugh it off, we're on the go. Shizzy Whiz, let's start the show. Let's go. Get it, yeah, oh yeah. Headlines spinning in the breeze. Stupid jokes, he's such a tease. Sip the Java, wear a smile. Pants are off, but stay a while. Morning Whiz and coffee. Talk the news, he's a tease. Laugh it off, we're on the go. Shizzy Whiz, let's start the show. Let's go. Get it, yeah, oh yeah. Serious is overrated. Every day we're caffeinated. Talk the town, but in a jest. Morning Whiz is always best. Ticking, time to run. Morning show's a load of fun. Grab your mug, don't spill a drop. Laugh your ass off till you pop. Clock is ticking, time to run. Morning show's a load of fun. Grab your mug, don't spill a drop. Laugh your ass off till you pop.
Oh my god, Shizzy breaks Larry. Shizzy broke Larry.